Greetings. I'm very glad to see that you're all here this morning. My presentation is having it both ways, how charter schools try to obtain the funding of public schools and the autonomy of private schools. Before I get into a discussion about charter school basics, I'm just going to tell you a little story, an anecdote, and about how it was that I really began to study the private and public distinctions of charter schools. Now, as you're all aware, charter schools are deemed to be these sort of these public schools which have flexibility from rules and regulations of state school, rules and regulations that apply to traditional public schools. And really, I always joke that charter schools help get me tenure, because I have been writing about charter schools for about 20 years, almost the entire time that I've been a professor. And I was really intrigued about the sort of issues that arise in charter schools. And in fact, I wrote really the first book on charter school legal issues. I was hoping that it would make my career in terms of paying for my kids' college, but it did not, because they didn't buy it. But, oh well. But I was, but I just wanted to point out how much I've been doing a great deal of research about charters. And one thing that I'd always assumed, really, was that charters were public schools. Because if you look at the literature about charter schools, if you look at all of the statements online, it's always said that they're public. And so as a school law person, one who writes about educational law, that has meaning for me, what it means to be a public school. And so what really sort of put me down this path about really examining the distinctions between charters, public and private nature of charter schools, was in 2011 when I was invited to talk at a conference of public charter school attorneys. I should point out that's what they title themselves, public charter school attorneys, to talk about the issues of charter schools and civil rights. And I figured this was going to be a very short talk. You know, it's like, well, charters are public schools, so they have to comply with civil rights. I figured I'll go there, speak for a few minutes, and then go and enjoy the sunny beaches of San Diego. That did not happen. So I went into the session and started talking about charter schools and civil rights, and the attorneys looked at me as though I was from Mars. They're like, we don't have to do any of that stuff. School desegregation? That doesn't apply to us. And I mean, we went back and forth in a very animated discussion. And so what really then turned my head about this, it really made me think about this, was a case that had just occurred, which I'm going to talk about in my presentation, a case called Cavness versus Horizon Learning Center. And this is a federal court of appeals case in which the court found that a charter school was not what we call a state actor with respect to employment, meaning that because it was not a state actor, it did not have to comply with the Constitution with respect to teacher rights in this case. And so my response is, well, that's an employment case. That doesn't apply with everything else. And they said, no, Dr. Green. If you look closely, the test that applies to Cavness could apply in other contexts. So I looked a little more closely and concluded that they were right, that there really were distinctions in that, depending upon the forum, this really could have a major impact as to what charter schools would be required to do. And so this became really the context of all of the research that I've been doing in charter schools up until the present day. So with that, I want to talk about really what charter schools are. And charter schools really are this sort of contract through a charter between a charter authorizer and between the charter school operator and an authorizer. An authorizer can be a school district, but it could also be a state department of education. It could be a university, depending on the state. And as I've said, charter schools receive a great deal of autonomy from state rules and regulations, but then in exchange for that autonomy, they are held to accountability standards that are laid out in the charter. And the failure to comply with those standards after a 3 to 5 year period could result in the charters being revoked from that school district. The charters being revoked. And full disclosure, for many years when I was in Pennsylvania, I served on a charter appeal board. And so I actually sometimes help to reside over situations in which charters were about to lose their charter. So I've had that experience in terms of having to issue rulings on revocations of charters. Now, as of 2013, 2014, it's already estimated that there are about 6,400 charter schools in 42 states and Washington, D.C. And this is probably the most popular educational reform. This is the reform over the last 30 years that's really, really caught the imagination of the public. So that's sort of like charter school. Those are Charter School Basics 101. But while charter schools are deemed to be public schools, they're really hybrids. And I just wanted to sort of provide you with the extent of my sort of graphic knowledge on PowerPoint to sort of lay this out. I'm an attorney, we don't do PowerPoint. So I just want you to sort of understand that. So I'm really proud of this. but yeah, yay me. But what I want to talk about is sort of like the differences between traditional public schools and charter schools. Now, if you look on the left side column, you'll see that public schools, traditional public schools, are operated by school districts, they're governed by school districts, and they're managed by public school officials, principals, superintendents, and the school board. So they're, in each of those, understand that they're accountable to the public. You know, school boards are elected. If they're not, you know, if the school boards are seen as not doing what the population thinks they should do, they can be voted out. But in many states, charter schools are somewhat different. Notice that they can be opened by private authorizers. You know, these are persons who are not beholden, and they're also governed by private boards. They are independently run. You know, these are like usually nonprofit entities that run these charter schools, and then many charter schools then contract out to charter management organizations. These are private entities that provide a variety of services to charter schools. Most notably, in many cases, they actually provide the actual teachers, the training of teachers, and then the actual teachers. So you have a number of instances in which the charter schools are not really sort of like completely beholden to the public. So this then brings me to really kind of like, you know, so while they're hybrids, the point is that charter schools argue that they're public though, because they're open to all students, they're tuition free, they do not have special entrance requirements, and they're secular in educational programming. So if you look on the websites, this is how they argue that they're public. But understand in the previous slide, I pointed out that they're really hybrids that combine both public and private characteristics. So this led then to my one visual besides the PowerPoint presentation. This is the law review article that, there it is. And I'll give you signed copies later on if you're interested. But it was actually an Emory Law Journal called Having It Both Ways. And this was co-authored by Bruce Baker, a long friend of mine at Rutgers University, and a former student of mine, Joseph Olawale, who's a professor at Montclair State University. And I point this out because you may be familiar with Diane Ravitch's recent work on educational reform. And when she talks about charter schools and having it both ways, a lot of her references is actually to a blog post between Bruce and myself, where we are going back and forth, really talking about these sorts of distinctions between the public and private nature of charter schools, and really the legal differences that, you know, why this may matter. So what we first found, so there's really three basic assertions in the research that we've been doing on this issue about charter schools and the public and private distinctions. And that is that for funding purposes, under state constitutional law, charter schools argue that they're public. But in other characteristics where it suits them, for teacher and student rights, charter schools argue that they're private. So they're public for funding and private for other stuff. And then the third point that we make in our article, which I will talk about at the end of my presentation, is that the that charter schools have to be very careful about the venues that they argue that they're public and the venues that they argue that they're private. Because what we're seeing very recently is that charters have begun to argue that they're private in state constitutional, in state context. And by arguing that they're private, they actually could then eventually expose themselves to challenges that they're ineligible for funding under state law. Because a number of state constitutional provisions prohibit funding the private schools, and they also prohibit funding the schools that fall outside of the system of public schools. So they have to be very careful about extending that argument too far. So let's talk about this idea that charter schools are constitutional for funding purposes. Now, in the mid-1990s and early 2000s, there were a number of challenges to charter schools in which plaintiffs argued that they were not public, but rather they were private. For instance, they argued that charter schools were really private schools and thus ineligible for funding. And then in a number of cases, one in Michigan and one in California, the courts found that charter schools actually were public, even though they were independently operated. And the major reason that the courts cited they were public was that the state had control in terms of opening charter schools, in terms of funding them, and in terms of closing them. So they're saying that in the end, the state operated or exercised control through those means. And with respect to the question about uniformity, they were so different from the system of public schools that they could not be funded. A number of states have such constitutional provisions. The courts found that they were actually part of a uniform system. And the big reason was that they were beholden to the same accountability standards that apply to traditional public schools. Students had to take the same tests, and then the failure to achieve those tests could result in the charters being sanctioned. So that was another way that state courts found that charter schools were actually part of a system of public schools. So while I've said that they're public for those purposes, then in the research we find that charter schools actually have been considered private in other contexts. In one area that has raised a great deal of recent litigation is the area of collective bargaining. Now, nationwide, about 35% of public school teachers can collectively bargain. But in charter schools, that number is around 12%. And charter organizers have argued against charter schools forming unions because they say that unions may actually prevent them from having flexibility. But unions have seen, because charter schools have, unions have noticed that because charter schools are becoming more and more popular, that they're no longer fighting against charter schools, but they're actually saying that charter school teachers need to unionize. So the NEA has become very involved in trying to organize unionization efforts for charter schools. But this brings then to sort of major legal differences between state law and then the National Labor Relations Act, which governs private schools in terms of how public schools can unionize. Now, in state labor laws that do allow for public schools to unionize, in most cases, public school teachers can actually decide to form a union through what we call a card check procedure, where a majority of the teachers say, hey, we want to form a union. We'll check that off. But under the National Labor Relations Act, which governs private organizations that decide to unionize, they actually have to do it through secret ballot, which takes a lot more effort. Another difference in state law for labor unions is that if there's an impasse, a mediator or in some case an arbitrator can come in and then try to broker the differences between the two. So there's an impasse, they bring you together and say you can all get along, try to work this out. That is not required in the case of in case of the National Labor Relations Act. There's no real effort to bring organizations together, And also another important distinction is that the employer can actually come in and actually try to influence the votes of teachers. So those are major differences. And so the NEA and any sort of union, if it wants to organize a charter, unionize charter schools, is going to want to go through state law rather than through the National Labor Relations Act. But understand, though, that before I go into the recent cases on the National Labor Relations Act, that in all of these statutes dealing with charter schools, what you find is that they all say that charter schools are public schools. They're also part of a political subdivision. They are agencies. To lawyers, this is language stating that they're public. And that means that there's a sort of meaning that goes with that, with that language. But what what the attorneys have been trying to do is to say that that language doesn't really matter. What we look at is the particular context that we're dealing with. And in that context, even though that language says that they're subdivisions, political subdivisions, or that they're public, in the specific context, they're really private. And in a couple of cases, the National Labor Relations Board ruled in favor of the charter school attorneys. They said that even though the language, these are two Illinois cases, that even though the language said that charter schools were political subdivisions or public schools, that language did not matter, and that they were indeed rather what we call employers or private entities. They're private entities, and so therefore they are beholden to the National Labor Relations Act. And the reason why in the Chicago mathematics case and the Pilsen learning cases that that the National Labor Relations Board found that they were private was because that in the pertinent language dealing with employment, it said that the charter schools were the ones that made the decisions about employment. That was the difference. They were the ones who had the control. And so therefore, that meant that they were private. So that really was a shock to people when those decisions came out. I should point out that this is beyond the context of our discussion, but there's a great deal of issue right now with the composition of the National Labor Relations Board. So right now, those decisions are not applicable. But it's important to understand that, at the time that they came out, this is a real sort of wake-up call for a lot of people about what it meant to be, what a charter really was. So that's one difference that I just wanted to talk about. Now, another area in which charter schools have argued that they are private is the area of state action. Now, for those of you who didn't go to law school, you can spend a whole semester talking about what state action is. So I'm going to give you State Action 101. But I will tell you that when I used to talk about this to my law students, our eyes would glaze over and just say, okay, when will it stop? So I'm not going to really spend too much time, but just sort of give you the basics here. Understand that public entities, organizations that are like public entities have to comply with the Constitution, they have to comply with federal statutes. So to understand that, private entities do not. So private schools do not have to comply with the Constitution. So therefore, they can, so for due process for students, for instance, they don't have to provide it. They don't have to, deal with the 14th Amendment. For teachers, they don't have to provide it. Search and seizure, no. So so there are major differences between how a private school would operate and a public school would operate. So this brings us then to the question about, well, what are charter schools? Are they public or are they private? Again, what did I say? All the charter school statutes say what? Charter schools are public schools. So what does that mean? You figure the Constitution applies. The Cabinet's case comes up, and the facts of the case are very interesting. You have a charter school teacher with for lack of a better word, boundary issues. This teacher was boundary challenged. This teacher had a lot of inappropriate relationships and contacts with students. I didn't really feel sorry for this teacher, I'm going to be honest about this. Although for constitutional purposes, this is wrong. But anyway, the teacher was then terminated. Now, if this were a public school, if the teacher is terminated for inappropriate behavior with students, the due process clause is implicated. And the reason that is because the teacher's reputation is being implicated. And so when you have these major reputational issues, then the school has to provide what is called a name-clearing hearing, where that teacher gets to say, I'm not that bad person you say that I am, here's what happened, really I can explain. But there are, and then they get that before they get fired. But but there is this sort of opportunity where the teacher gets his or her say to explain what had happened. The charter school did not provide that. Charter school said, you're done, you're gone. So the teacher then went to court and said, that's unfair, that's wrong. I am a public school teacher, so therefore I should get this name clearing hearing. Charter school's response was, not so fast. We're private. We're private with respect to employment, so therefore we don't have to provide any of these sort of technical issues about due process. That doesn't apply to us at all. So the case then eventually goes to the Ninth Circuit Court of Appeals. And the Court of Appeals looks at the Arizona charter school statute, and sure enough, charter school statute says that charter schools are public schools. And they said, so that doesn't matter because public doesn't really mean anything for us. What we want to look at instead is, what does it mean with respect to employment? And what the court then said was that what we want to see is that with respect to employment, are charter schools required to act as a traditional public school would? In other words, would it have to comply with the Constitution with respect to terminations? So the court looked at the charter, they looked at the enabling statute, and they found no language actually compelling the school to act as a public entity would. And so therefore, because that was the case, the court found that the charter school was not a public school with respect to employment. So therefore, it didn't have to provide due process. So this brings us back then to the discussion that I had with the charter school attorneys, where I started this talk about, where I said, well, that's only in the employment context. And what they said was, we think this could apply to other contexts. The other important context for me would be students. So what would happen if you use the cabinet test for students? If you look at most charter school laws, they don't really say anything about due process other than that the charter school has to provide a discipline plan to be approved by the authorizer. That's the general rule. There are no real sorts of requirements about them having to act in the same way a public entity would, or the same way that a traditional public school would, with respect to student rights. So if you think about that, that means that, under that type of test, then you don't have to provide due process for students. And you've been listening probably to the news recently, and you know that in traditional public schools, you find that that students of color are suspended and expelled at an inordinately high rate in public schools, where we have due process. So you can imagine the concerns that arise where you don't have due process. I mean, this is a major, major issue. And when I started talking about this, I wanted to think about how that is, how could this actually occur? And I think that what people are beginning to realize is that there's really, and what charter schools have been able to do in these instances, is really take advantage of the fact that there's really no clear understanding of what it is to be a public school. That if you, and in this article where, we have like 300 or 400 footnotes, if you really want to go into 350, footnote 350, you can find how we talk about how state constitutions define public school. And you talk about being open to all, being under the control of the state legislature or voters, but there's no language about student rights. So when you think about that, it's conceivable that a court could repeat this and say that student rights are not required under state constitutions. So because that's not part of the definition, this is something that sort of like falls between the cracks. And so this becomes really, really an important issue that my colleagues and I have been really trying to get people to pay attention to. And so it is not just due process. Think about First Amendment. First Amendment, speech. First Amendment, search and seizure. These corporal punishment. These are major issues that if charter schools are not public schools, these are the sorts of issues that arise for students. And so, so this is something that, and I should also mention that charter schools are now paying, that school districts and state legislatures are paying a little more attention to the issue of due process. And so there are instances, where they're calling for more or changing of the rules with respect to student rights. So we're seeing some differences there. So I want to talk very briefly about, then I'll open it up to for questions that you may have. I started this talk to discuss sort of like really the ways in which charter schools might have to be very careful in terms of maybe making themselves ineligible for funding under state law. And there are two issues that I think, that I see right away that people should be paying attention to. First is parent involvement contracts. You may have heard about this, where the classic bake sale contracts is that you will spend 10 hours at a bake sale, and of course you will go cook cupcakes. I don't think they want to eat my cupcakes. There would be a lot of dead children after that. But I will say, or not, but there would be some food poisoning there. But there are a number of charter schools have provisions that say that they require the parents to perform a number of hours of volunteer work, and the failure to do this volunteer work could result in their students being removed from the charter schools. And they always say, well, we have a waiting list with parents who are ready to do all of those bake sales. Now, this could raise a major question because many states have constitutional provisions that require public schools to be free. And free means free. In terms of, so if you're actually doing voluntary service in exchange for your children's being in that school, one could argue that that's not free. You're doing something, and so therefore, there are some schools that may actually by doing this, may actually make themselves ineligible for funding. Another area that is really in the news these days is the issue about teacher evaluation systems. Many of you may know that since 2009, that states have really revised their teacher evaluation mechanisms to require the use of student performance, student achievement data. And many of them are using value-added methodology, statistical methods which try to tease out sort of like the value that an individual's teacher may add to student performance. Now, you may be surprised, but many charter schools have been fighting against that. And they're fighting against that because they're saying, and they have their reasons, partly because many charter schools are theme schools. They have specific themes, and sometimes these themes don't completely align with the testing, even though they probably should because they're all tested in these areas. But they become very concerned. They also say that there are many cases through anecdotal evidence that they say, well, we can always cite these charter schools that are actually using student data to make decisions about tenure, to make decisions about termination. But if you look at the statutes themselves, you find that many statutes actually exempt charter schools from the requirements of these new teacher evaluation systems. And in an article that I have coming out with co-authored by Morgan Donaldson, who's also in Neag, in the Journal of Law and Education, we point out that this may actually expose charter schools to another type of state constitutional challenge, and that is that they're not a part of a uniform system of schools. Remember at the beginning of my talk, I said that charter schools said that they were part of a uniform system because they have to comply with the same accountability approaches as traditional public schools. And there's one case in particular, in Ohio's Supreme Court in 2006, in the Ohio Parents and Teachers case, had said that the court said that charter schools were indeed eligible for funding because they're a part of a system of public schools. And one of the reasons why the court said they were part of a system of public schools was they had to comply with the same accountability. And they said that, but they also said that the major differences, there may be some differences, charter schools may not have to comply with certain provisions, but then the court said that those differences were picayune in nature. That's a legal way of dissing somebody. That's a legal diss. It's like, this is just really not that important. But understand that this decision came out in 2006, 3 years before the whole teacher evaluation revolution. And so it may be very hard to argue that this distinction is picayune. And because accountability is such an important aspect of education, and teacher quality is seen as such an important aspect of education, this may not be the type of distinction that a charter school may really want to highlight. So these are the sorts of issues really that are coming up, in the near future. Another area that I have not really talked about, but I think that really, I will say that I'm really paying a lot of attention to, really is the issue about, about fraud and mismanagement, and about the use of funding by charter management organizations. That is another area that really one should pay attention to. And I will also mention another issue that I've been really playing with, and that is there are cases out there. There's actually an Ohio case, I believe, right now, where the charter management organization is saying that it used all this money that it received to actually buy computers, equipment, and then after the charter schools were closed, they didn't want to give it back. They said it's ours. So why do they say it's theirs? Because they say, well, we're a private entity, we get to keep it. And they may actually win. They may actually win on that statutorily because, they may not be public entities. But think about this in terms of state constitutional. There are a number of state constitutions that require charter schools. They require all systems and all public schools to be part of a thorough and efficient school system. I would argue that that's not exactly efficient. To give millions of dollars away and not be able to get it back. So these are the sorts of things really that that I've been working on, and I just want to close by saying that sometimes people think that I'm an enemy of charter schools, and I'm not. Charter schools really are here to stay. They are. But the thing is that if they're going to be here and if they're going to be part of a system of public schools, then we have to come up with a way of ensuring that they operate within that system. In that accountability, actually regulations are a way to do that. And we've already had those experiences with mortgages, with other instances. And I always say that, if we're not very careful, that education may be the next bubble. So we really need to take steps to ensure that that doesn't happen. And so I'm really thankful to be here and to have this forum through my endowment to the Carla Klein Endowment to be able to make that case. So I thank you very much, and we'll open up to questions now. So the question is really kind of like, how does accountability play out for a charter school teacher? And I think that the answer depends on the charter school. The answer really does depend on the charter school, that charter schools are given a great deal of flexibility. And in many states, that flexibility also applies to like the rules for hiring teachers and for terminating teachers. So in a lot of these questions, it's really a state by state issue. And so if you're really like a student if you're looking to be in a charter school, you do want to check out the laws of that state to determine like what types of rights that you have. And then, decide if that is important to you. Now, I'm going to say that for every teacher, it may be different. A lot of students come in and they say that the flexibility that they may have may enable them, may be very attractive. And so, I don't want to be seen as saying, don't go to a charter school to be a teacher. I'm not saying that at all. But this is certainly something that you may really need to think about. And if it's a case where you find a school that may not provide you with those protections and that's important for you, then you may decide that traditional public schools may be a better bet. Yes. So the question is sort of like, how do student rights play out in the charter school context? That's the question. With respect to disability law, this could become very complicated. If you're an agency, like a local educational agency, then IDEA then applies. And so in most cases that, they are federal disability statutes do apply to them. I'm going to point out that in the 90s and 2000s that many charter schools did not realize that. And so they actually fight against that. And I should also point out that charter schools have also engaged in the practice of counseling out. And that is that they'll say that while we're able to serve you, this may not be the right school for you. So you may want to think about going someplace else. So that's how that plays out with disability. Now, with respect to the issue about student rights in the Constitution, I'm going to tell you I'll give this difference by talking about this Louisiana case in the mid-1970s. And I can't remember, I think it's called the St. Augustine case. And I'm going to give you the facts in this case. Private school had a policy that said, students, if you get caught smoking a cigarette the first time in school, you'll be fined $5. If you get caught smoking a cigarette the second time in school, you'll either be fined $10 or we'll expel you. So second time, $10 or expulsion. Our little geniuses got caught twice. So the nicotine got to their heads, I guess. So they then said that, all right, well, we'll pay the $10. School's response is, no, we're going to expel you. Students said, unfair, and then they sued. And they said, well, because they're a state, he's like, we should get due process. We should get a hearing. Court's response was, well, if you were a public school, yes, you get a hearing. But you're a private school. So you don't get due process. All they need to sort of state what the procedures are. And in the language of the court, as long as they follow the color of due process, that was sufficient. Yeah. So therefore, because they actually had the rules, they were not completely laughable, the court then found that the court fell in favor of that private school. So that's a big difference. And that could be a big difference for a search and seizure. That could be a big difference with respect to discipline. And I'll give you another case. This is a private school case. This was out of the First Circuit. There's a federal Court of Appeals for the First Circuit ruled on this in a Massachusetts case. Not a Massachusetts case, a Maine case. You understand that in Maine, very few people, there are just very few students in Maine. I guess it's just too cold, I don't know. But, but there was one school district. So a lot of these districts actually have agreements with private schools. And so, and the private schools then provide that education. So there was one child who was, a problem child. The school kept him out for 30 or 40 days and gave him no due process. No hearing, nothing. Then he came back. The student then sued and said, wait, you have to provide me with due process. And the court's response was, well, even though there's this agreement, the school that's providing this education is a private school, not a public school. So therefore, you don't have to provide due process. And so the question becomes, well, what about the state constitution? You have to provide some sort of rights for students, right? The court's response was, no, the Constitution only requires that you provide the students with an education. So, if they're not in this school, that's all that, they did come back. So therefore, there is really no deprivation of an education. And so this is a major impact because because you have this move toward charter school districts where whole districts are forming charter schools. And so what you're having is this sort of system of hybrid schools that are saying that they're not, they can say that they're not public with respect to discipline. And so therefore, what could happen in that situation is that you could have students who are not actually, who are like out of school. And you actually saw this in a recent California case where charter school, where a student actually really just suspended a child from a charter school, didn't want the kid back. The kid then sued saying, well, wait a second, I'm being deprived of an education. The court's response was, well, you really weren't expelled. You still have that option of coming back into a traditional public school. So they can still take you. And so really you aren't that harmed. But any person who knows how really kind of like the effect that suspensions and expulsions can have on children, they may not be so cavalier about that. And so, so these are the sorts of issues, the real concerns that I have with respect for student rights and due process. Well, there's an interesting subtext in the National Labor Relations Act cases I was just talking about. And that is that charter schools there's an interesting shell game that was being played, some good attorneying, if that's such a word. What they were doing was saying in these right to work states that, well, we don't have to, it's like they're not unionizing under state law, but they're also hoping that the National Labor Relations Board would not get into the business of unionizing. Because under the Bush administration, they weren't actually really active in terms of allowing private entities to unionize or really being active in that. But in these recent decisions under the Obama administration, what happened was that, they were actually not happy that the NLRA actually exercised jurisdiction and said that, they can unionize under federal law. And so this was they were actually unhappy about this. And so this was actually one of the reasons for which you had this big tension and really kind of inactivating right now the NLRA because of these decisions. So the subtext is that right to work states actually weren't happy because the effect of this case was that they could actually unionize. But again, this is also sort of like one of those unanticipated dangers for making these arguments about saying that you're public here and private there, because by doing that, they might have caused the federal government to be that much more interested, and so that much more concerned about providing some oversight over charter schools. Well, I thank you very much for coming out here this Saturday. I hope that you have a great rest of the day, and I'm glad to see you here celebrating the 15th anniversary of Neag. Thank you.